how an attorney really prepares for trial. That's what we're going to be talking about today, and here is my fancy graphic showing you exactly what today's topic is, how an attorney prepares for trial. So stand by as we get ready to get started, and I'm going to share with you some really cool insights how an attorney prepares for trial. So come join me in just a few moments as we get ready, and we're going to be talking about how an attorney prepares for trial. So here we are with my fancy 3D graphic. For those of you who have been watching my videos, my Facebook Live videos, you know that I prepare a very, very expensive, fancy graphic, none other than a three-dimensional 3D graphic. You see how three-dimensional it is? It's on a piece of paper that goes by as I move it. Amazing. Nobody else uses this strategy. Why not? Because they want to use the fancy latest technology, and you know what? That's great. I prefer using something so much better, which is how an attorney prepares for trial. And here's my fancy 3D graphic. So we're going to get started in just a moment. As more and more people show up, we'll be able to give them some great information. And now they'll know exactly what it is that I'm talking about today. How an attorney prepares for trial. Here's my fancy graphic. Better than a ticker tape. Here we go. There you go. And I'm going to share with you exactly why this is such an important piece of information, even if you're not involved in a case currently, even if you don't know of somebody who's got a case, because this will give you a real insight into what an attorney actually does as they get ready for trial, unlike what you see in the movies or on TV. Unlike that. Okay, what you see portrayed in the TV and on the movies is so dramatic and so different than what goes on in real life about how an attorney prepares for trial. So we're about ready to get started, and I want to thank everybody for joining me today. I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney, and we're shooting video indoors today because it's raining outside. So again, we're talking about how an attorney prepares for trial. So I'm focusing right now on civil lawsuits, not criminal, but civil lawsuits involving accident matters and medical malpractice matters and wrongful death matters. Now, when you watch shows like Law & Order on TV, what happens is you've got 30 minutes worth of police investigation, and then the next half of the show involves the trial or involves steps leading up to the trial. You rarely see the actors thinking about and strategizing and showing you how they actually prepare their case for trial. All of a sudden, 45 minutes into your show, guess what? The case is on for trial. 45 minutes, 35 minutes into the show, your case is on for trial. Well, that's nice on TV, but it never, ever happens that way. It's impossible to happen that way. So let's take another show, the movie A Few Good Men with Jack Nicholson and Tom Cruise, a military trial. So the entire movie leads up to the entire trial involving the two Marines who are accused of killing someone. Right? And in that movie, you actually do see some strategizing and how the attorney actually prepares some of the trial. And that's a very interesting look because most films, most shows do not show you what goes on behind the scenes of how an attorney actually prepares for trial. So I'm going to give you a step-by-step breakdown to give you an understanding, a real understanding of exactly what happens when your case is approaching trial. So again, I'm focusing on civil lawsuits. And in New York specifically, which is where I practice, that's what happens here in these civil cases involving accidents, medical malpractice trials, and even wrongful death trials. So now what happens after the discovery phase is finished, where each side has had an opportunity to learn from the other exactly what happened and what their defenses are. Now we tell the court that the case is ready for trial. Now that does not mean that the judge says, okay, come tomorrow and now we'll go ahead and have your trial. No. There's a whole stack of other cases before yours that must get to trial first. So there's a big backlog. And what that really means is that your case is not going to come on for trial for many, many months, depending upon which county your case is in. In some counties, there's a backlog of 6, 7, 8, 9 months. So you're going to be waiting a long time. And it's going to appear to you, the injured patient, the injured victim, that nothing is going on in your case. You're going to feel as if, hey, you're waiting forever. But the reality is that there's a lot going on behind the scenes, stuff that you don't see. And now I'm going to expose it. I'm going to reveal that to you so that you get a good understanding of what really goes on behind the scenes as an attorney prepares your case for trial. Because I want to tell you something. Preparing a case for trial doesn't just take a few days. It doesn't take a few weeks. It can take months and months. That's ideal, where an attorney has the opportunity to prepare your case and has many months leeway in order to do that. That's the best opportunity. That's the best thing, because you need a lot of time to go ahead and prepare. So while you're twiddling your thumbs waiting for your case to come up for trial, here's what goes on behind the scenes. Your attorney has now told you that your case is on the trial calendar. All right, what happens first? What happens now is that the attorney has got to go through the entire file all over again, from start to finish. He has to identify those pieces of documents. That makes no sense. He has to identify what evidence he wants to introduce at the time of trial. Is it going to be your medical records? Is it going to be some other documents? If so, now he has to get those records into court so that when your case is now on for trial, he can then go ahead into the subpoenaed record room, which is where those records are sent, and now he can take it and use those records at trial. It's very important that there is a continuous line from the time it leaves the doctor's office or the hospital's office showing the chain of custody. That's very important in order for him to be able to use those records at the time of trial. So, that's the first thing. The attorney has to identify what medical records or what other documents he's going to need in order to show that you are more likely right than wrong. That's part of the proof that he's going to be putting on. In addition, he needs to understand and try and figure out what type of exhibits is he going to use during the course of trial. An exhibit is nothing more than an enlargement or an illustration or an anatomical model, something that will help the jury understand exactly what the issue is and what the problem is. So, when you're thinking about what models, what diagrams, what exhibits you're going to use at trial, the attorney has to try and identify what's the key issue. Let's say it's a failure to diagnose lung cancer case. Well, it might be a great idea to have a large anatomical drawing of the lungs and show the different parts of the anatomy of the lungs. Excuse me. So now what you do is there are different ways to get these anatomical drawings, and now you enlarge it. And you can enlarge it to 30 inches by 40 inches to make it a huge poster size. And then you have to put it on a foam poster board. So now you can come into court, put it up on an easel, and now when our expert gets up to explain to the jury exactly what this is about, now the jury can follow along and see exactly what part of the anatomy the doctor's talking about, so they have a clear understanding of exactly what went on. Also, since we use computers often, and now we have projectors, and we can put that information up, show the jury, it's also important for the attorney to identify what information, what documents, what diagrams are useful for the jury to see using a projector, using the laptop, or maybe there's animation that he wants to be able to show the jury. Those things have to be thought out, and now you have to go about getting that stuff ready in the weeks, months leading up to your particular trial. So while you're waiting and nothing's going on according to you because your attorney's not communicating with you and not telling you, listen, here's everything that I'm doing behind the scenes getting your case ready, you think he's doing nothing. Well, in reality, that's a bit different. Plus, he may also be entering into settlement negotiations. And the only time you're going to learn about that is if the defense actually makes an offer. He's got an obligation to communicate that to you. All right, so we talked about what we call demonstrative evidence. Stuff that we can show and tell to the jury. What can we show to the jury so that our witnesses, our experts can go ahead and explain? That's very important because the jury actually loves show and tell. Remember when you were in grade school and there was show and tell? What could be better than that? You have time out of your day from learning, and now some kid comes in with some really cool object, and now they teach you about it, they show you about it. The same exact thing happens with these types of cases where now we have to think about what it is that we can show and tell the jury about that will help them understand the anatomy, help them understand the medicine, help them understand the key issues in this case. So that's just one aspect of preparing your case for trial. So now, what's another thing? Well, you should know that during the course of the discovery part of your lawsuit, each side had an opportunity to question the other people involved in the case. And now all of the answers that you gave and all the questions that you were asked got put into a booklet, into a transcript. And now the attorney has to go through each and every pre-trial transcript to not only familiarize himself and re-familiarize himself with, hey, Don, nice to see you, with exactly what was said and what the answers were. But now we go ahead and have to outline exactly the information contained in those transcripts. And also we want to highlight certain testimony that was given, because you should know that those answers that you gave and answers that the people whom you have sued, those answers constitute trial testimony or pre-trial testimony, and they carry the same exact weight as if you were testifying at trial. The only difference is there was no judge present, there was no jury present in your attorney's conference room. That's the only difference. But now I can use that transcript and I can go to the jury and say, ladies and gentlemen, 1 year ago, this witness was asked this question and gave this answer. And now you heard from this witness yesterday, and he told you something totally different. And he contradicted himself in just a year's time. And now I can show to the jury that this witness might be less than truthful, this witness might be lying, this witness may have forgotten something. But using a pre-trial deposition transcript is a phenomenal way to understand exactly what went on, and a phenomenal way to show contradictions between witnesses' testimony. So we have to go through all of that testimony. Another aspect of getting your case ready for trial involves identifying who the defense's experts are. Because in malpractice cases in New York, we don't tell our opponent who exactly we're bringing in. Instead, there's a different component. We have only an obligation to tell our adversary, our opponent, that, hey, listen, we hired a medical expert who's a specialist in lung diseases. He went to this medical school, he did his training here, he now did a fellowship at this location, and he's licensed to practice medicine in New York, and he's board certified in pulmonary medicine. That's what we are obligated to tell our opponent. And now, what does our opponent do? He does his research, he takes that information, he plugs it into a computer program, and guess what? He identifies exactly who that expert is. And now what happens? What happens is that he will try and dig up some dirt on our expert. Why? Because he wants to use it for purposes of cross-examination at trial. This is all part of the process of how an attorney actually prepares a case for trial. Each side has to identify who the other side's experts are. And now, once we've identified who the expert is, or experts are, now we have to try and dig up dirt to see, number one, whether this expert has ever testified before. Number two, if they have, now we have to try and obtain transcripts, trial transcripts, from the attorneys who participated in those trials. Then we have to read through each and every one of those transcripts to see whether or not this expert has contradicted something he said from that case to something he may be saying in this case. Because we're obligated to tell our opponent what our expert will be talking about. And this is fantastic information that will help us during cross-examination if we're able to dig up some dirt. And if we can get something that's devastating, let's say it turns out that we learn that the expert was convicted of a crime of Medicare fraud. Well, guess what? We can use that information at the time of trial. But unless an attorney spends a great deal of time preparing for trial, learning this information, there's no way to ever learn it or to ever know that this is going to happen. So this is some of the stuff that goes on behind the scenes that your attorney likely never tells you about. And there are a number of reasons why they may not. They may be busy, or they may not just want to have a detailed, lengthy conversation with you about all the necessary steps to prepare your case and get your case ready for actual trial. So again, this is another component of what an attorney does behind the scenes so that now this gets your case ready for trial, because I want to share something that likely is going to be eye-opening for you. The best way to ensure success in your case is for the attorney to be totally 100% prepared. If he's not prepared, now you are at a significant disadvantage, because guess what? We are preparing as best we can. Likewise, the defense attorneys are also preparing the same exact way. They're just doing it from their viewpoint. So, you'd think that nothing's going on in your particular case. Weeks and months are going by. You don't hear much information. But in reality, there's a lot going on. all the attorney has to do is tell you, hey, listen, now I'm going ahead to get transcripts. Now I'm going ahead to publish exhibits so that now we can use these enlargements at the time of trial. Or now we're going to be creative and get additional photographs of what you look like now and compare it to what you looked like before. So you have before and after photographs. All of these things go to help the jury understand exactly what is going on with your case. So what else do? We also make sure that we know exactly where every document is. An attorney has to be extremely organized because during the course of trial, now during the middle of cross-examination, if I want to confront a witness with a particular document or an exhibit, I need to know exactly where it is at a given moment. Oh, Exhibit 7, where did I put that? Judge, could I have a few minutes? I have to search through my things to try and find... No. You'll find that the best trial attorneys are the ones who are meticulously organized. They know exactly where their papers are. They know where their exhibits are so that they have it right at the touch of their finger. Or, here's a better example. Let's say it's now cross-examination. And now I want to confront a medical expert with something that he said in a transcript a few years earlier on a different case. I need to have that exact page ready to go at that exact moment. I don't want to have to sit and scramble and wait for 30 seconds or 2 minutes to try and find that and then thumb through all the pages to see where it is. The attorney looks totally disorganized when that happens. And you don't want to give that the jury the sense that, hey, you're totally disorganized. You don't want to give the jury that loss of momentum that you have when questioning or cross-examining a witness, and now you're going hard and you're hitting verbally, not physically, okay? And now, all of a sudden you say, could you hold on 1 second? I've got to go through this paper and find out this transcript and find out exactly what page and what line and what question I asked. Give me a moment, Judge. And now you lose that momentum, you lose that energy, and that could be devastating, all because you were not organized. So it's critical for an attorney to make sure he knows exactly where everything is, where all the documents are, where every reference is to things in transcripts or in the medical records that he wants to use to cross-examine or to use at trial. So what have we talked about? We've talked about how an attorney uses all of these things to help you get ready, help him get ready for your case. So what else does an attorney do? An attorney also will need to bring you into his office to go through with you and to give you the types of questions he is going to ask you during the course of trial. Now, your attorney is going to call you as a witness, which means you will get up on the witness stand, and now it's your opportunity to explain to the jury in your own words exactly what happened to you and what injuries you suffered as a result of that. So you have to prepare. Now, that doesn't mean the attorney puts words in your mouth. It doesn't mean the attorney tells you what to say, but it's important to know what questions we're going to ask you. Open-ended questions such as, hey, Mrs. Jones, when you went to see the doctor, tell us what you said to him. Mrs. Jones, when the doctor examined you, what did he do? What did the doctor tell you afterwards? So I'm going to be asking my client open-ended questions. Who, what, where, when, how, why? Explain more. Tell us more. What did you do next? These are open-ended questions known as direct examination. And it is extremely important. And by the way, every single witness, every single attorney does this before the case actually gets to trial. You rarely see that in TV shows involving legal dramas. You rarely see that in the movies. Why not? Because it's not terribly exciting. Hang on 1 second while I take a quick water break. All right. So that's not terribly exciting because when an attorney prepares a case for trial, not all of this is very sexy. Not all of this is very fascinating, but it's necessary. It's critical in order to go ahead and make sure that the attorney is 100% prepared, because today we are talking about how an attorney prepares their case for trial. And it's extremely important that the attorney is 100% prepared and knows the case better than the client, knows the case better than anybody, so that now he has all that information at the tip of his fingers at a moment's notice. All right, so what's next? So in addition to preparing the injured client for testimony, we also have to prepare them for cross-examination. And cross-examination basically puts them in the position of, hey, listen, here are the questions you are likely going to be asked by the defense attorney when he questions you. And now, many times, these are going to be direct leading questions. Mr. Jones, isn't it true you saw my client on this day? Yes. And when you went into the office, isn't it true you made a complaint of difficulty breathing? Yes. And on that visit, isn't it true you had seen another doctor just a day earlier? Yes. So what the defense attorney is doing really is making statements and getting my client to go ahead and either agree or disagree. That's what a really good attorney does during cross-examination. They do not allow the witness an opportunity to go ahead and explain anything. They simply only want the witness to either answer yes, no, I don't know, or I can't answer that question. So it's important for a client, an injured victim, to understand what types of questions the attorney is going to be asking, the opposing attorney is going to be asking during cross-examination, so that they can think about the type of answers they're going to be giving. And again, you should know that when we prep our clients, I will tell you that even though attorneys may have a bad rap, when an attorney preps a particular client, they always tell them, tell the truth. Don't shade the truth, don't hide the truth, tell the truth. Because the moment you start to tell a little white lie, shade the truth a little bit, now all of a sudden that's going to come back to bite you in the butt. So, also I'll tell you another strategy that's used by opposing attorneys. Let's say when the injured victim gets up on the witness stand, and now they say, hey, Mrs. Jones, isn't it true you spoke with Mr. Oginski before getting up on the witness stand? And now the client is terrified of telling the jury, yes, oh my God, I spoke to my attorney. Guess what? It is totally 100% appropriate to speak to your attorney about this type of testimony, about the type of questions you're going to be asked, about helping you refresh your memory, involving stuff that you remember happening 2-3 years ago, and now you just have a brain freeze and you don't remember exactly. So, when the attorney asks in the middle of trial, hey, by the way, did you speak to your attorney? In an accusing fashion, they do it, this is how they do it. Mrs. Jones, isn't it true you spoke with your attorney before getting on the witness stand? And the clients are like, oh my God, if I say yes, the jury's going to think that the attorney told me what to say. No, no, no. All you have to do is tell the truth. Yes, that is true. I did speak to my attorney. Now, the opposing lawyer cannot under any circumstance ask what you spoke about with your attorney. You want to know why? It's because that information, that conversation is confidential. Confidential. It is private. It is privileged. So, we would jump up out of our seat, say, Your Honor, I object. If he tried to ask, what did you, Mr. Oginski, talk about? Objection. That's attorney-client privilege. And the judge would have to say, Mr. Oginski, you're right. Counselor, next question. Objection sustained, which means you are not to answer that question. Go on to the next question. That's pretty interesting, right? So again, we're going back to how an attorney prepares for trial. We've covered demonstrative evidence, stuff that we are going to use as show and tell. We've covered certain information that the attorney has to use to dig up on experts. We've talked about going through the trial transcripts of experts. We've talked about going through the pre-trial testimony of our witnesses. We've talked about communicating with our witnesses, and also our experts. We have to meet individually with our experts to, again, prepare them for trial. Why? Because this is exactly what an attorney does in the state of New York, in fact, everywhere in the country, if they're an experienced attorney and they know what they're doing and they don't get the file half an hour before they say, go pick a jury. That's what an experienced attorney begins to do. So these are just some of the things that an experienced trial attorney will do in order to reach jury selection on your particular case many months down the road. So why do I share this great information with you? I share it with you just to give you an insight and an understanding in what goes on behind the scenes that nobody tells you about. Hopefully this gives you a better look at what really happens in a civil trial. And now when you're watching a drama, a courtroom drama on TV, or you see something interesting in a courtroom scenario in the movies, you'll begin to ask yourself, okay, what did they do to get to this point? How much effort, energy, and resources, How much effort, energy, and resources did they put into the point where they now got to trial? And I will tell you that in these civil cases, attorneys put in hundreds and hundreds and thousands of hours of their time to get these cases ready for trial. And that's what a good attorney does. You know, I realize you're watching this video because it likely came up in your Facebook feed. Well, if you found this information helpful, if you found this interesting, what I want you to do is I want you to share it with all your friends so that they too can get the benefit of this great information. And if you're watching this on YouTube on the replay, in all likelihood, you still have questions about your matter, assuming it happened here in New York. Well, if your matter did happen here in New York and you have not yet started a lawsuit because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. I can answer your legal questions. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at, follow the bouncing finger, ready? 516-487-8207, here we go, or by email at, here we are, back again, Gerry, Gerry, at Oginski-law.com. Well, that's it for today's video. I'm Gerry Oginski. Have a fantastic day, everybody. Bye-bye.